I'm coming to you, Mr. Sanusi, but let me get to the senior advocate very quickly, because some of the pillars of democracy has to do with rule of law, human rights, and what have you. And many of the conversations we've had here today gets back to the judiciary. You have talked about the independence of the Electoral Commission, but there's still the valid question of whether or not our judiciary is independent. You see, most of our elections still end up in courts. And it speaks to a flawed electoral system. Some argue that it is mischief on the part of those who have lost. But there remains the real concern of undue influence by politicians on our judiciary. Where are we and what must be done differently?
Thank you. I think sometimes we mistake the judicial exposure to influence with lack of independence. When it comes to adjudicatory independence, Nigerian judiciary has adjudicatory independence, because there has been no instance where non-judicial officers have been writing judgments for them. But because they have not insulated themselves from political influence, the bias of their interests tend to reflect in how they adjudicate, especially politically involved cases. And I've said to you that the judiciary has bastardized electoral jurisprudence in Nigeria as a result of this, not consciously, but in their belief that as a third arm of government, one of their duties is to protect the stability of the state. They tend to give judgment on electoral disputes in a manner that shows that they are more interested in stabilizing the system rather than being unduly proactive. But the country that we are requires proactive judicial activism. For instance, today, I was with a colleague of mine yesterday, and he said they went to cite one of the judgments of Supreme Court in Botswana in an election matter. Now, Supreme Court in Nigeria will say that every single dispute you want to establish, you must call an eyewitness from the polling unit, regardless of the nature of it. It has got to the point that it's almost impossible now, unless we're talking about disqualification, to achieve anything in court over electoral dispute when you are the one trying to establish some form of dispute. And they said, look, they can't understand the jurisprudence. That a document has been brought that shows something has gone wrong. You say you must call a witness physically who witnessed it in polling unit. And then one of the reasons we amended the constitution to give time limit for electoral dispute was because we realized that if you are to challenge election, presidential election, you probably need to call about 30,000 witnesses in a space of about 3 months. How is that possible? So they then decided, look, let's limit the time, and they introduced provisions that say, look, if malpractice are manifestly disclosed on document, you don't need to call a witness because everybody can look at the document and decide it. Now, the jurisprudence of Nigeria, the way it is, the court has ruled, after we thought that was an escape route, to say that notwithstanding that provision that the legislature has come in to provide, you must still come and speak to the document. And if you are not the one who participated at the lowest level of election, what you are saying is hearsay. So it's almost, and then that is very important for our democracy, because when people begin to lose trust on the dispute resolution process after election, it can negatively impact the perception of how our democracy works. So there is need for intentionality about how we proceed in reforming our electoral dispute, number one. Number two is that it's not even necessary that you must always go to court for election. But I did a study more than 30 years ago, and I realized, and I keep on advocating this, there's a fundamental dysfunctionality in the way we run our own electoral system. And the reason why other political democracies are stable is the way they structure power, that people don't go to office and leave at the same time. So they don't conspire to return themselves. America has sustained this because every 2 years since 1770, there's always a need to go back for the electorate to reconfirm their mandate. Either you go for midterm election or presidential. And when one is going, it's not all the officers that are at stake. So people can actually accept defeat because they know they only have 2 years to wait. Something else can happen. It may not be them, but they can flip the House of the Congress. The president might lose majority in the Congress, even though he's still the president.
I hear Senator Rafkin.
So please, let me just stop you that. So there are some things we need to interrogate in how we structure the system itself.
Let's get this conversation to a live audience and hear from